Hello and welcome to Parley, the Hindu's weekly podcast where we explore pressing questions of public interest with insights from leading experts. I'm Aaratrika Bhaumik, your host for today, and the question that we're asking this week is: should commercial speech be regulated online? On August 25th, the Supreme Court urged the Union government to frame guidelines for regulating social media, noting that influencers often commercialize free speech in ways that can offend the sentiments of vulnerable groups. A bench of Justices Surya, Kant, and Joymalya Bagchi directed that these regulations be drafted in consultation with the National Broadcasters and Digital Association. This particular order stemmed from an intervention application filed by a non-profit representing individuals affected by spinal muscular atrophy, a rare genetic disorder. The NGO had alleged that stand up comedians such as Samay Raina, Vipul Goyal, and others had abused their freedom of speech and expression allegedly by making derogatory remarks about those living with this particular disorder. To discuss the implications of this particular directive as well as the broader concerns it raises about online censorship, we are joined today by Apar Gupta, advocate and founder director of the Internet Freedom Foundation, and Vinayak Ojha, senior resident fellow at the Vithi Center for Legal Policy. A very warm welcome to the two of you.
Thank you.
Thanks, Aaratrika.
Mr. Gupta, if I may begin with you. Now, in recent months, we have seen a host of Supreme Court benches make oral remarks, and also some have been reflected in orders about concerns regarding regulating social media and how online speech, that there is a violation of reasonable restrictions when it comes to online speech. To begin this discussion, do you think that we need new speech codes to regulate social media? Is there a regulatory vacuum in the first place?
So thank you so much for having me here. I do not think so. There's a regulatory vacuum. On the contrary, if you look at studies, as well as the particular instance in which the order has been passed for framing of guidelines, there is actually legal prosecution which exists. Because the very basis of the Supreme Court hearing this case are FIRs which were filed by the state governments of Maharashtra and Assam under various sections of the BNS, which is the Bharatiya Nyaya Sanhita, as well as the IT Act for criminal prosecution for a stand up skit which was done. Secondly, in terms of regulation, which goes beyond the bounds of a criminal prosecution, under the Information Technology Act as well, there is a censorship mechanism under which different types of content online can be taken down pursuant to court orders or directions by executive authorities, which is right now in force. Quite often, this is done without uh, adequate natural justice. This is done quite often in secrecy. So, I think so. The anxiety of the court, which is emerging as to a vacuum in the law for prosecution of speech which is there online, emerges more from concerns around sentiments and lacks a constitutional foundation.
Right, and you do believe that this is an instance of judicial overreach because what is also important here is that in most of these cases, at least, uh, none of the petitioners or interveners were actually asking for regulating social media. We had aggrieved parties come for clubbing of FIRs, for instance. So, do you also see the court going beyond the prayer asked in these petitions?
So, if you look at the case itself, which is before the Supreme Court, it emerges from a large amount of moral panic that is emerging from a stand up skit done by Samay Raina. And it's called India's Got Latent. A lot of young people watch it, and the concerns which are quite often voiced emerge from the perspective of its impact on young Indians. Primarily a morality based concern rather than a legal based concern. Now, if there is obscenity within the remarks of the show, which leads to FIRs being filed in different states, the petitioners who are arraigned as accused in those FIRs seek the protection of the court from imminent arrest and ask for those different FIRs in different states to be clubbed together. This has been done even earlier in several cases. For instance, Arnab Goswami is one particular instance that litigants approach the Supreme Court saying that there are multiple FIRs in different jurisdictions. Please give me some protection. Please club them together. Hence, the jurisdiction of the court is limited actually to the prayers which are being properly. It's limited to the prayers which are before it. uh, it's undeniable the court has inherent jurisdiction. It can look at the wider social impact that speech is having. However, it has to do it within the bounds of law. To my mind, this instance links to another recent instance which of court issuing directions and trying to fill in a purported vacuum in law when it does not exist. And that instance is the stray dogs order, where it is l- letting its own anxieties overtake itself rather than dealing with what are the case and what is the case before it, what are the facts before it, and what is the proper role of the court in adjudicating the dispute.
Right, right. Mr. Ojha, what is your opinion on this? Do you agree with Mr. Gupta that there is not a strong constitutional foundation when it comes to the court's anxiety in these matters?
I do agree, but I think when we ask, has the court overreached itself? We do have to ask, where is the baseline? What counts as overreach? And if we look at the court's jurisprudence over the last 45 years, I think it slipped the bonds of what is traditionally understood to be the judicial role a very long time ago. Um, so to ask whether the Supreme Court of India has overreached its bonds is a bit like asking, can God create a stone so heavy that even he can't lift it? Because the precedent for these extraordinary interventions was laid a very long time ago, and it's now more or less become accepted even by the government as a legitimate player in public policy rather than just in the settlement of ordinary disputes.
Okay, right. So are you referring to the inherent jurisdiction that the court has under Article 142? And that,
The use of the inherent jurisdiction is one part of it. I think the development of the PIL jurisdiction over the last few decades is also a part of it. So, for example, when it comes to guidelines, in this case, we are dealing with an oral remark, which in which the court has asked the government to consider framing guidelines. But in the past, in the Vishakha case, for example, the court has itself framed guidelines. So it's difficult, I think, to say whether the court has overreached itself.
right. So we have seen, you've obviously mentioned a couple of precedents, but it is quite established through Supreme Court precedents that any restriction on free speech must adhere to the specific grounds mentioned under Article 19, Clause 2 of the Constitution. Now, when we look at these particular batch of matters where we have had several benches make oral remarks, what we see is that the court bases it on the fact that there should be a balance between freedoms and duties. And also, a couple of benches have remarked how individual dignity and the public participation of, let's say, specially abled people must be respected. So, do you share these concerns, and do you think that, there can be restrictions on the basis of these grounds?
Well, certainly, it would be strange to say that one doesn't share those concerns, especially regarding the public participation of differently abled people. But as you pointed out, it is well established in precedent that the grounds for restriction of freedom of speech in Article 19.2 are exhaustive. And you can't really go beyond the four corners of those when restricting the freedom of expression. So I do think that it is a slippery slope to say that based on a somewhat amorphous or less clear concept like dignity, which hasn't really been defined in law, one can restrict freedom of speech or freedom of expression.
Okay. Mr. Gupta, I'd like to bring you here. What is your opinion on this? And since we are discussing the reasonable restrictions under Article 19.2, how has the court actually interpreted morality and public order? I mean, does morality under Article 19.2 depend on the shifting moral sentiments of the public?
So, one way to think about reasonable restrictions is that there are certain grounds under which law can be made, and that law needs to be reasonable. Okay. And for a constitutional law, any constitutional law, if you look at the way Sirvai's commentary, for instance, on constitutional law breaks it down, is that for that reasonableness to in that law to be made, it needs to be a act of legislation, because ultimately Article 19(1)(a) is your right to freedom of speech and expression, which is being abridged or restricted by these reasonable restrictions, for which there needs to be a valid procedurally passed law, either through an act of legislation or delegated legislation under it. Secondly, then it needs to connect reasonably to the grounds which are there, such as public order, decency, morality, etc., etc. So here, reasonableness as a concept itself also gains a certain degree of significance, where reasonableness means that, is the restriction proportional? Is that restriction tied and is coming through very immediately from the grounds which are there under 19.2 by itself? And here, while, for instance, individual dignity is an important concept, and I think in the Subramaniam Swamy judgment, in which the constitutionality of criminal defamation was upheld, dignity did was read into as one of the bases under which criminal defamation as a remedy was upheld. uh, Even then, I would say that uh, reading dignity as a freestanding ground for, and especially on the basis of somebody feeling individually hurt, or allowing people on the basis of hurt sentiments, especially in the day and age when we are awash with media, is just letting a huge amount of censorship proceed, not on the basis of an objective legal criteria of what is a reasonable restriction, but what is in fact an individual's hurt sentiment by itself. This in no way, in terms of what I'm saying, is an endorsement of jokes, or a protection towards those jokes. However, we must quite often realize that acts of literature, stand-up comedy, things which we think are deeply uncomfortable, sometimes show harsh truths to society, sometimes question us, sometimes it also makes us wonder, why are people laughing at a joke regarding a disability? Is it because are not providing enough respect for people, enough protection for people, enough access for people who are differently able than us? These are the kind of questions which sometimes comedy does provoke, and I think Justice Oka has also recognized this in one of his recent judgments, expressly stating that Article 19(1)(a) is not only for the protection of speech which is palatable, which is acceptable, and which should be celebrated, but also for criticism, even for things which hurt us at a social, at the level of our social values, not only in terms of questioning government power, etc., etc.
Right. Mr. Ocha, do you agree? I mean, how would you respond to what Mr. Gupta is saying? Do you think that there is also a fear where, such regulations can be used to censor unpalatable speech, so to speak?
Oh, yes, I'd like to echo that entirely. That is exactly the problem, which is the use of dignity as a sort of freestanding concept independent of any law in force. It's entirely possible that there are uh, restrictions on the grounds of morality or defamation, which also have a bearing on the dignity of an individual and where dignity ties into it. But exactly, it is the use of dignity as a freestanding ground uh, to restrict freedom of speech, which is perhaps not constitutionally permissible. Um, there, the on the question of the chilling effect, I think that's always a concern. It's difficult to imagine that a stand-up comedian looking at what these five comedians, whether we think they're funny or not, have been through, would be as free or as open in performing his or her act.
Mr. Gupta, what is important in the latest directive is that Justice Surya Kant's bench has remarked, this has of course not been reflected in the order, that the right to free speech does not extend to speech made purely for commercial purposes. Now, my question to you is twofold. First is commercial speech constitutionally protected? And second, before framing any such regulation, is it important to first distinguish between, let's say, commercial expression that advances public interest to some effect, and commercial expression that is purely based on private commercial motives?
Just because something is commercial does not rob it of its value in deepening a social conversation. Consider the nature of our society. It runs on commerce, it runs on trade. The very metaphor which is used quite often for free expression by many people all over the world is a marketplace of ideas picking up from justice homes. If you look at the case law from the Supreme Court of India, the press publication cases. For instance, look at Sakal newspapers. The union government posed a choice. It was not direct censorship. They didn't say, Sakal newspapers, I don't like what you publish, close down tomorrow. They offered them a form of a choice between reducing the number of pages, thus the substance of the breadth of expression, or raising prices, affecting their circulation and access. At its very core, there was commerce involved. However, that commerce facilitated the ability of a newspaper to carry more reporting and the breadth of that reporting to be made accessible to more people. Even this podcast, which is being run by a media entity in some way or the other. And that's how the media ecology works. If you consider stand-up comedy, for instance, a venue needs to be paid, a stand-up comedy needs a comedian needs to make a living. If you think about, let's say, any other form of cultural production, a movie or the burgeoning Indian hip hop scene, they have cuss words in them quite often. There is a commercial element attached to it. So either if one looks at the our society and the value of what constitutes content which is commercial or purely for commercial gain, the presumption that it robs itself of any kind of value which it contributes back in terms of circulation, even a book is sold, for instance, right, is a wrong notion to hold. And for this reason, there is actually sufficient precedent from the Supreme Court, directly and indirectly. Directly, it will be MTNL newspapers revising the standard of Hamdard Dawakana, or it will be Sakal newspapers, or even Shreya Singer, which
Hmm.
recognizes the safe harbor for large social media platforms which are which are having GDPs more than many countries itself, which is an issue, I would admit. But yet, at the same point in time, just because speech is commercial, or it is our perception that certain things are being said on social media for people to sound more outrageous and thereby more people to be hooked on to what others are saying and thereby for them to enjoy a financial windfall, is a correct incorrect basis to frame regulation itself. Hence, I think it is not a very credible approach to take, to adopt everything. Every second thing on the internet in some way or the other will be quote unquote monetized.
Right. Mr. Ojha, what is your response to this? Do you agree with Mr. Gupta that, I mean, do you believe that commercial speech should be treated differently because there is this profit making element to it?
Yes, I do agree with what Mr. Gupta has said. In fact, it is somewhat surprising to even hear this case being tested on the anvil of commercial speech, because, as Mr. Gupta mentioned, when you look at the Supreme Court's jurisprudence on what is called commercial speech, if we see Hamdard Davakhana, that was a challenge brought by makers of certain remedies to the restrictions on advertising under the Drugs and Magic Remedies Act. Or if one looks at Tata Press and MTNL, that was about publication of advertisements in the yellow pages. So, and even that was held to be protected speech under the freedom of expression provisions of the Indian Constitution. So, the speech of comedians or journalists or satirists has not really been considered commercial speech before. Now, when it comes to advertisements, there are I would say the Supreme Court has, while recognizing it as part of the freedom of expression, it has treaded a fine line because certain provisions, such as compelled speech provisions in relation to tobacco advertising, have been upheld. But I don't think that stand-up comedy has traditionally been considered even a part of commercial speech.
Right. So, from a policy standpoint, how do you think regulation should look like? Which kind of balances interests of balances the freedom of speech and expression, the right to freedom of speech and expression, and also upholding the dignity and rights of specially able people or vulnerable groups.
At the risk of sounding a bit flippant, I think we should start from the presumption of don't fix what isn't broke. I think, as Mr. Gupta mentioned, these cases themselves stemmed from a number of FIRs. So there are already provisions, whether in the intermediary guidelines under the IT Act, which apply to social media companies, or the general criminal law of the country, which applies to all of us, on what you can and can't say about certain groups. One might question the wisdom of any individual one of those provisions, but this does exist. So I think it's almost trite to say that hard cases make bad law. Certainly, I don't think I didn't find Mr. Raina's joke funny. I think it was in extraordinarily poor taste, but based on this one incident, to create this whole spider's web of legislation, or subordinate legislation or guidelines or whatever it may be, on what people can and can't say online, and to create an entirely new system of penalties, which is something that was hinted at, I think might be a bit of an overreaction.
Right. And how important do you think stakeholder consultation is going to be when it comes to framing such regulations? Of course, the court has directed that the union government has to consult the NBDA. But how important do you think stakeholder consultation will be, especially when we see recent laws being passed, whether it's the online gaming bill or since we're talking about digital media, the broadcasting regulation bill. What stakeholders have pointed out is that there has been no consultation whatsoever. So, how important do you think that is?
As someone who works in public policy, I can only say that stakeholder consultation is very, very important. But I think it's also important to define stakeholders in the right way. One can't simply say that, those who want, if one defines stakeholder so narrowly, that only those who want some restriction are defined as stakeholders. I don't think that's fair. I think you have to consider those who would be speaking and those whom the speech affects. So it's the devil is always in the details, but of course, stakeholder consultations are very important.
Right. Mr. Gupta, coming to you now, what experts have flagged is that we have 34 judges in the Supreme Court, which kind of gives it a polyvocal character. Now, if you look at the last couple of months, we have had orders and judgments which have upheld the freedom of speech. And we've also had interventions, judicial interventions, where speech has been gagged, and there has been punitive measures taken uh, against the against respondents, so to speak. So do you think that because of this polyvocal character of the court, we end up having a patchwork jurisprudence, so to speak, where we see so many benches actually not follow precedents laid down by coordinate benches? Do you think this can pose a big problem?
A polyvocal court does not take away from the character of the court being a court of record, which means that it has to follow the law which has been laid down by it in previous decisions, and in a different fact situation in which that precedent is inapplicable or needs to be incrementally modified for its application, its sum and substance is still maintained. I think what we are dealing with much more recently, of course, will be the polyvocal character, which may emerge from comments which may be made by different judges, but may not find them in formal orders or directions which are issued ultimately. So it may just be an exchange with a lawyer, or a curiosity by a judge, or a conversation during the midst of arguments. I think that is something which will be in the nature of a court being polyvocal. Of course, I acknowledge that there is divergence between courts, not only in the Supreme Court but even in high courts, and precedent is not a ironclad objective criteria. It's not pigeonholed. It's not a algorithm which gives a consistent output at every point in time. These There are human frailties which attach to the judicial process. However, I think this the nature with which adjudication is being approached increasingly, especially in this Ranveer Alabadia matter, gives me
Hmm.
a lot of cause for concern. For instance, I'm reading the order in front of me, which was
Hmm.
issued, and
Hmm.
it says the last question you asked me, there is a reference to stakeholders shall also be invited. It does
Hmm.
not mention who those stakeholders will be, how
Right.
will the invitation. Is the stakeholder consultation the same as a public consultation? It does not square against the obiter of the Supreme Court for public consultation and administrative processes for improved transparency in judgments, such as the TRAI call drop case, where Justice Nariman, I remember, stated that there needs to be, especially when there are public impacts of any regulation, it needs to be not only a stakeholder consultation, it needs to be a public consultation. It doesn't even refer to the pre-legislative consultation process. It doesn't define any timelines. And the reason I'm saying all of this is that these regulations are not in a atomized or isolated manner being made by the Ministry of Information Broadcasting, which was recently also proposing to bring in a broadcasting law in which each and every creator would require a prior registration with them and need to follow stringent guidelines, which could be a
Hmm.
cover for censorship, media regulation, etc., etc. The risk which comes through this is that this is a determination which is emerging by a union, by a body of the union executive, which is the Ministry of Information Broadcasting, on the basis of a direction of the Supreme Court. Thereby, it also undermines any potential challenge to its constitutionality in future, because this is a court directed exercise at the end of the day. Hence, it will have a presumption, not only of the standard presumption of constitutionality, but a double bonded presumption that this is not only an act of the executive or the legislature, but is on the basis of a direction of the court. Thereby, going to the court and challenging it at a subsequent point in time will be doubly difficult. Hence,
Right.
again, going back to your question, I do
Hmm.
not think the reasoning of the court being a polyvocal court here excuses this determination and the concerns which are emerging from it at this point in time.
Right. And since you brought it up, I mean, do you, now that there's a stronger clamor from the judiciary when it comes to stronger regulation for social media, do you see the center kind of reviving the broadcasting regulation bill in some form?
See, as per public information, which is what I have before as per the records of the Standing Committee on IT, which have been made public, the Ministry of Information and Broadcasting, despite substantial public criticism, still on record has not withdrawn the proposal for the broadcasting bill. It is an active proposal. And yes, there is a danger, there is a reasonable apprehension that given that the subject matter or what the court is directing the Ministry of Information Broadcasting to do, and what the Ministry of Information Broadcasting just a few months ago was wanting to do, are
Hmm.
very, very similar. It may lead to a form of regulation, or it may lead to a proposal which may be similar in aspects to the broadcasting bill. Because, for instance, who is an influencer? How do you apply this? Do you apply this even to people who are making entertainment videos which are offending people? For instance, you look at a viral Punjabi song in which there is a huge amount of social criticism for the characterization of young women in it. Will it lead to a censorship of that kind of song? Is that person an influencer? These are very complex questions. Once you tread down the path and you say, yes, what I want to see on the internet should serve a social value, and only a social value within the bounds of morality which is accepted by large sections of the society, it will lead to en masse censorship, or pick or choose censorship at the very worst.
Right. Mr. Ojha, what is your opinion on this? Do you think that, I mean, if you look at the free speech jurisprudence uh, in recent times, do you think it's heavily reliant on the discretion of individual judges?
I think this ties in to the question of polyvocality, which we were just discussing. I think in most common law systems, and India is a common law system, polyvocality has always been a feature, and this debate between legal certainty and elaboration of the law based on the views of individual judges has always been a debate. So if we zoom out a little bit and we take a global view, Um, Lord Mansfield in the 18th century in the House of Lords in England tried to clamp down a little bit on this tradition of extreme polyvocality that the House used to have, and he tried to insist that the House give one unified judgment. That didn't really last. The American Supreme Court, in its early days under John Marshall, also tried to become a more monovocal court. That didn't last either. I think there is something in the nature of the common law system and how powerful our judiciaries are, uh, that each judge does feel, and with justly so, that his or her views might contribute to a development of the law in the future, and so why not put them down, whether it's a dissenting opinion or a separate and concurring opinion. So I think that to some extent in our system, that's inevitable. Now, if you look at countries where courts are much less powerful, like France or Germany, Germany is a bit of an exception now as its court has grown more powerful. But these are largely monovocal systems, the civil law systems, and they prioritize certainty above all else. Now, I don't think we should confuse the issue of coordinate benches issuing conflicting judgments with the concept of polyvocality. Because if a coordinate bench issues a judgment that is at odds with an earlier coordinate bench,
Hmm.
um, that is simply, I would say, a breach of judicial discipline, because it is bound, and the right thing to do is to refer it to a larger bench, as has been done in the last couple of years with a number of important commercial law issues, some constitutional issues as well.
Last question for the evening, Mr. Gupta. I'd like to start with you. Now, if you look at we have a very opaque takedown regime, right, under Section 69A, as well as the 2009 blocking rules. Do you see where, when the union government is empowered to come up with these regulations, do you see such concerns being extended here as well? Where, I mean, can you foresee an opaque takedown regime there also?
The answer to that is fairly obvious. The takedown regime, which is there right now, is also being further diluted in many ways. For instance, the Internet Freedom Foundation, which is where I work also, give part of my time, has been part of a challenge before the Karnataka High Court, which has reserved its judgment on the constitutionality of a portal called Sahyog, which is being challenged by the social media platform X, which was formerly known as Twitter, but also by Digipub, which is a collection of independent news publishers and journalists, where we are representing Digipub, lawyers from IFFI. So, in Sayog, for instance, there's a online portal. Uh, as per a notification issued by the Ministry of Electronics and IT, any central government or state government official can be nominated, and then it's pretty much a technical platform in which a takedown order is uploaded and a social media company complies with it. There's no notice to the eventual person who's posted that content on that social media platform. So opacity in content takedown, censorship, website blocking is an ongoing feature of how web content is being taken down in India. It's something which is very central to it, and if these influencer guidelines are or these directives are formalized into the force of law, I think even if there is no criminal penalties which result from it, if it's even just censorship, one does not know that how will it be applied and what transparency in this entire process will be adopted. And this is not only important for the creators, this is also very important for people from all of us in India who get to access the internet, because the very basis of our ability to form opinion, our ability to disagree with something, to laugh at something, to react to something, is on the basis of that something, is on the basis of a piece of literature, is on the basis of a piece of writing, a news report, a song that we see, a movie that we watch, a stand up which we disagree with, a joke which we do not like. So, I would say that it hollows out not only the right to freedom of speech and expression for the person who's the creator, who's the author, who posts this content on social media when they do not get the ability of natural justice, which is a hearing, the ability to respond, legally contest it, but also it hollows it out for the broader public discourse, which quite often which is fostered by it.
Right. Thank you, Mr. Ojha. Any concluding thoughts? And also, if you could speak a little about, in your opinion, what safeguards should be built into the regulations so that there is no misuse?
Well, I'll conclude with some words from Justice Scalia that I always remembered. He was once asked on how he drew the line between whether a particular restriction was constitutional or unconstitutional. And all he answered was, "You draw it very, very carefully." And sometimes that's the best answer you can give. As to what safeguards might be built in, I think review mechanisms are very important. No decision should be, a first decision should not be a final decision. And I think, on the whole, a respect for the constitutional values of free speech should be reflected in the law itself, and uh, should be ingrained into the people enforcing it, as fanciful as that may sound.
Right. Thank you so much. Thank you very much for your time, Mr. Gupta and Mr. Ojha.
Thank you so much.